Hello, hello, hello. This is Tony Mike Gravel coming to you from Chicago, as usual, where the Wi-Fi works more often than not. We got some fun stuff here. I have to look these up here. Who do I need to thank? It's hard for me to tell. I'm looking here. Chidaskadam, A. Taranenko, and Zach FL. The best I can do. I also have a fun nugget in here from Lucificent's Lair. Let's get this party started, shall we?
Thank you, Your Honor, for your assistance.
State your name, sir.
For the record, I am the executive office holder of the estate of Douglas James Young Jr., the executive beneficiary. I'm the executive beneficiary.
Tell me your name, sir.
I'm the executive beneficiary of the estate for Douglas James Young Jr.
Set a $500 bond. Your next court date is October 30th at 8:30. Have a good day.
Step to your right to the T. When the green light comes on, sign for your copy. Next.
So this was in January of 2024. So in the whole year of
Okay, this is Lucificent's fault. It's a child support or alimony type hearing in Tennessee. It's delicious. I just snipped a bit of it. It's long, but I just snipped the juiciest part.
2023, you did work overtime.
When I did, yes, ma'am.
So your wife, when she came to court, did not present money about what you actually were making. She did it on your base salary, didn't she? And this was the time where you left your family and were having an affair with your daughter's cheer coach, nonetheless, correct?
Right.
And you've impregnated her.
Yes, ma'am.
And you're about to have another child with her.
Yes,
and when does that child due?
Everywhere.
I like the indignation with the Southern accent. I mean, he is just literally getting nagged senseless by opposing counsel. It's painful, but it's funny.
In February. So when you testified that the reason, and I may have misunderstood, don't have the best hearing, but you testified that I recalled, Mr. Holly, yeah, I'd like to get this child support lowered so I can make my truck and other payments. That's what this is about, is because you can't live your lifestyle the way you want to do it. And
live your lifestyle. She's got some good points. What she's doing, this poor guy needs an attorney, though. She's hammering him and saying, basically, you didn't disclose income at the last hearing. But the problem is, the burden is on them to produce the evidence. That's what's going on. But it appears he's unrepresented because he's just up there getting hammered. Of course, he wants to reduce payments to increase his own lifestyle. That's a silly argument. You want to reduce payments to everything. If you could pay less for your electric bill, you would. If you could pay less for your divorce, you would. If you could pay less for your mortgage, you would. Duh. That goes without saying.
Still support your family.
Well, and it's not about the truck. I'd let the truck go in a heartbeat. It's the fact that I need a vehicle so I can get to work, so I can keep my job.
Well, but let's talk about that, because Mr. Holly came up here and advised the court that you were living with your mama. And that's what you had told him. Again, don't answer that question because that's attorney-client privilege. But again, that stuff.
Living with your mama. I just love it. These are phrases you do not hear in court in Chicago.
Statement wasn't true. You're living up with your girlfriend, aren't you?
I'm back and forth in between my mom's house, my parents' house, and her.
Where'd you spend last night?
In Waverly with a girlfriend.
And where'd you spend the night before?
My parents' house.
At your parents' house?
Yes, ma'am.
Because what, you had to go do the MRI and your mama carried you and paid for it? Is that right?
I'm sorry, say again?
You went back to your mama's house so she'd pay for your MRI? The attorney's okay, but she's running over a guy who's not represented. I have a lot of responses to all these questions, but she knows she's not going to get that. So she's just smacking them around.
Did you spend the night with, why'd you spend the night with your parents?
That's my other home.
Your other home. And you were out riding around in the rain with a friend. What friend were you riding around with?
Richard Lindsay.
Richard Lindsay. Now, you and Mr. Lindsay had a little bit to drink, hadn't you?
No, ma'am.
It's your testimony here under oath, under penalty of perjury, sir,
I understand.
that you had not drank anything on the night of your wreck.
No, ma'am.
You had not.
No, ma'am.
Would you please state, I had not drank any alcohol on the night of my wreck? Would you?
I had not drank any alcohol.
That's his testimony. I mean, I get her point. She's like, you're going to sit here in open court and tell the people of Tennessee that you went out with your buddy on Friday night riding around in your truck and nobody drank anything. Okay.
On the night of my wreck.
Okay. Had you taken any non-prescription medication?
No, ma'am.
Let me rephrase that. Any non-prescription medication that was somebody else's prescription?
No, ma'am.
That's your testimony.
Yes, ma'am.
Did you seek medical treatment that night?
So it was late night, early morning, and no, I didn't, because I wasn't going to be out of the emergency room in time for me to make my anger management class in Franklin, Tennessee, that I had to be there at 8 o'clock in the morning for.
Okay. Well, what time?
And his response is, no, I was being good because I had to make it to my anger management class. I'm sure court ordered in the morning. You can't make it up.
Was the wreck?
It was probably a little bit past 1, 2. I'm not sure.
1 or 2 in the morning?
Yes, ma'am.
What you doing running out and around? What night of the week was this?
Friday.
Friday night, and you knew you had to go to an anger management class,
Yes, ma'am.
and you were out riding around with friends in the rain until 1 or 2 o'clock in the morning.
The reason I left was because of the rain. The rest of the night had been perfect.
Well, so you had money to ride up and down the roads. Where'd y'all go?
We just rode around Humphreys County.
And it's your testimony here under oath. And again, you know Humphreys County's a pretty small place.
Yes, ma'am.
A lot of people know a lot of people around these parts.
Yes, ma'am.
Okay, and it's your testimony you didn't stop anywhere?
Gas station, maybe.
Didn't stop at a bar or an establishment
Don't make me call Billy Bob to prove you're lying.
that had alcohol?
No,
Didn't go into a gas station to buy beer?
no, ma'am.
Sure about that? Okay. And what time did y'all start this riding around junket that you were on?
I'm not sure, to be honest with you.
Not sure.
I didn't quite get that. Did she call it a riding around junket? I don't know. It's good.
Don't know.
No, ma'am.
But you went back to your girlfriend's house
Yes, ma'am.
and wrecked in the pine needles
Yes, ma'am.
and didn't seek medical attention.
Was the time, and I don't know.
Pretty simple. Did you seek medical attention that night? Yes or no?
It was later on that same day.
After you went to your anger management
Yes, ma'am,
11-hour class?
Yes, ma'am, because if you miss one of those, it's like 3 months later before you can make up that class.
Red X, sir. State your name.
Oh,
Is this Daniel Sparks?
Yes, sir.
I'm going to appoint the officer to represent you, Mr. Sparks. You're before the court today for your first appearance. You've been arrested. Alleged you're accused of.
this is from the same call as the intro. This guy gets in his feelings, and our favorite deputy gets in there too.
Justice out of Kentucky. I am going to ask Griffith to explain to you the process of extradition and resolve anything this morning. Mr. Griffith, if you don't mind.
No, sir, I don't mind. Mr. Sparks, do you understand what's going on? You have an option. You can agree to go back to Kentucky voluntarily. To do that, you would sign a waiver of extradition, some papers, and the judge will have you come back to court if Kentucky hadn't picked you up in a couple of weeks. If you don't agree to go back voluntarily to Kentucky, you wouldn't sign the waiver of extradition, and you would stay here in our jail for up to 30 days. They could get an extension for another 60 days, so you could be in our jail for 90 days, while the governor of Kentucky and the governor of Florida see if they can get things worked out. They'd have to get a governor's warrant to take you back in voluntarily. Now, if you do that, you won't get credit for any of the time you spend in this jail if you receive a sentence in Kentucky. If you waive extradition, you get credit for any time you spend in this jail if you receive a sentence when you get back to Kentucky. Do you know what you want to do?
I'm not fully understanding. You said that I can go there voluntarily.
Yes.
And what is that?
But that doesn't mean you'll get out of jail and hitchhike back. That means that they'll hold you in jail until the authorities in Kentucky come get you.
And how many days would they have to go?
This is the most I've ever seen this guy get to talk. I mean, I always use his stop talking about your case clip, but he's getting into it here on extradition.
Give me.
It's kind of indefinite. The judge will give them a certain number of days, and if they haven't gotten you back, then they'll place some phone calls and try to find out what the problem is while they haven't come to get you.
My issue is my children involved. That's my biggest issue. The reason why I came down here with them is because I was doing everything I could as a father to protect them. They were currently in a situation where they was being abused by the mother. She was residing in the state of Illinois.
Mr. Sparks, that's
Yes, sir.
right now. I can't consider any of that. All I'm gonna consider is I'm gonna hold you in jail.
But my kids are still out there.
Mr. Sparks, I can't help that there's a warrant out of Kentucky, and that's what we're dealing with this morning.
I know, but the one is for custodial kidnapping. But what I'm trying to tell
Mr.
you,
Sparks, I didn't find the
Yes, sir.
probable cause. The judge up in Kentucky issued the warrant. And I'm gonna hold you without bond until Kentucky comes and gets you, or the.
and right
or
now
the-
I got a gunshot wound to my leg too, sir, and I'm not getting no medical attention for this either.
Mr. Sparks, that's not before me today either. The question is whether you want to waive extradition or you want to wait and let Kentucky get a governor's warrant.
I have no idea what to do. I have no idea.
Okay, so you're not waiving, so I'm gonna just leave you in jail until they come and get a governor's warrant.
My kids is
Yes, sir, I understand that, and I'm sympathetic, but there's nothing I can do about your children this morning. You got a warrant out of Kentucky. You're in Florida.
I know, but that one was just signed on the 24th. We've been down here this whole month. If that was the case, how come it wasn't filed at the beginning of the month? We've been down. My
Mr.
son
Clark, you ask me questions I can't answer. I'm just telling you, you're not getting out of jail until something happens in Kentucky.
I need to know what my kids is at, sir.
Mr. Sparks, I cannot answer any of those questions. Question before you today is, do you want to waive your right to extradition and allow Kentucky to come get you, or do you want to
I don't
stay
know
here?
what would be best. I don't know what would be best for me to do. I have no idea.
Wait for it. He's about to go full chili.
You want to go fast or slow? That's the best way I can put it to you.
I wanted to go fast. I need to get back.
You have to waive to go faster. They gonna give
I
them
can be
time.
here up to 90 days if I waive it, right?
No, if you don't waive it, they give them 90 days to get that governor's warrant. Either way it go, you'll be here at either 30 and, well, probably before 30 or up to 90.
If you sign a waiver of extradition, I'm gonna have a return date of December 3rd. And Mr. Sparks, this is the time to pull yourself together. There's nothing I can do.
I'm sorry.
I understand. This is
My
time.
kids
This is
are
the time.
afraid, I'm sorry.
This is the
And
time
I'm
to
in a
make.
lot of pain, too.
It's time to cowboy up.
I don't know what to do. I don't know
All
what
right,
to do.
All right, well, let's just.
I'll waive it, I guess.
Okay, well,
Best thing.
sign slate. And I'll have a return date of December 3rd.
Is there any way it could be any quicker, sir?
Well, I'm just giving Kentucky that time to get, they could come get you before then.
Well, could you give them a little bit less time?
Well, you're still not guaranteed to get out that time. That's just when we're going to look at it again.
I don't understand this. I don't understand why I'm not getting represented on this. Will I have another court date on this?
Mr. Griffith has done everything.
Judge, he doesn't understand why he's not getting represented. Come on. It's a fair question.
He could for you this morning, sir.
Let me see. All right, he's not signing, standing.
I'm hurting my leg. I've been shot in my leg, and I don't have no medicine. Nothing.
All right, I've spent all the time I'm gonna spend on Mr. Sparks.
He's signing. He just signed. So he can finish signing over there.
I've had enough of this crybaby. Get him out of my way.
There's 5 copies of the same one. Next.
We're just playing hide and seek, Ms. Podolsky.
Calling case
Oh, this got sent to me again from Discord. This is good stuff.
2024-2849 BC, Mary Aldering versus Stephen Smith. Today is Monday, October 28, 2024 at 9:56 a.m.
Court will note the appearance of Ms. Podolsky on behalf of the plaintiff and defendant appearing in pro per. This matter is before the court on the plaintiff's motion for temporary custody, support, and parenting time. Ms. Podolsky.
Thank you, Your Honor. This, as we stated in our motion, the parties have one minor child together. He is 3 years old. Parties were in a dating.
For the record, for all you whiners out there, in this particular case, the wife is absolutely right. She's more than generous. She has her life together. And the guy is completely in the wrong. There you go.
Relationship until about August 14th of this year, at which time that relationship ended. And since then, the defendant has had no parenting time with the minor child. My client has offered him parenting time, but he has not availed himself of it. The defendant does have a history of drug use, his drug of choice being methamphetamines. My client has witnessed him using methamphetamines. He's witnessed him holding paraphernalia in the party's home. He is currently not working. We did identify his last place of employment in our motion. He was terminated from that employment after refusing to participate in an employer-mandated drug screen. And he has a March of 2024
Objection.
Case.
Hearsay. Hearsay.
In the 10th District Court for possession of drug paraphernalia. We do believe that he may have other criminal matters outside of Calhoun County and even outside of the state of Florida. And we have concerns that he doesn't have a valid driver's license, but in any event of using substances and transporting the minor child. We do believe that it would be appropriate to issue an order of sole legal and physical custody to my client. She has been the sole caretaker of the party's minor child since birth. She is a fit and proper individual to care for the party's minor child. And she is proposing a parenting time schedule. That would be a supervised visitation schedule to occur on alternate weekends, supervision to be done by the defendant's mother. And that if defendant did fail to attend a visit or left early, that his mother could continue that visit, as she is an important person in the minor child's life. My client is not trying to take the child's paternal family away from him. She's just simply trying to keep the minor child safe and knows that defendant's mother can do that. So we're also asking that if defendant does appear at one of those visits under the influence, that he must leave immediately. And his mother has agreed that she would terminate those visits if that happened. Because of the drug use and the significant history, we're asking that the defendant undergo a substance abuse evaluation, a psychological evaluation, and follow the recommendations of both, and with those evaluations provided to our office, as well as participate in drug screening prior to parenting time. We did outline my client's income information in the motion. We don't know if the defendant has gotten a job since we filed this matter. However, we do believe that he could work. He could work 40 hours a week and he could go out and earn $20 an hour, but would have to participate in employee mandated drug testing and be able to work. So we are asking that the court impute him at $20 an hour, 40 hours a week for the purposes of child support. Thank you.
Thank you. Mr. Smith, what's your response?
Unmute. Mr. Smith, please unmute.
Oh, he shows up.
Got me muted.
Okay,
Oh,
we can hear you
Can you
now.
hear me?
I'm at fuel.
Yep, go ahead, sir. What's your response?
I have filed my Hague application to your office, Your Honor. And have you received that?
No, I have not.
I wasn't served papers until the 18th of this month, and today's the 28th.
Judge, have you received my Hague application? No, I haven't.
I saw that the papers were drawn up on the 2nd of October. If you haven't received that, it is in the mail. But I, because of time, I can go over the Hague application that I have currently, and with my LLC on the articles of organization, that creates this address as my home state, and I'd like to apply that. My home country.
Sir, I don't care. Just respond to the motion. I don't care about all that other stuff.
That is my response to the motion. Before we further this custody battle and waste more time of the court, the Hague application takes precedence, and I would like that applied.
The what application?
The Hague application, Hague Convention application.
I have no idea what you're talking about, sir. I know what the Hague Convention is, but I don't know what you're talking about having filed because I haven't seen it yet. So I'm asking you what?
Well, the court has a file of it, and now I have sent another file to you. I have one in front of me. Obviously,
I'm asking you to tell me, sir. I don't have it in front of me. I'm asking you, giving you opportunity to tell me what you filed.
Okay. I came this close when I was in the Netherlands of going to the Hague. It's not far from Amsterdam. I just didn't have enough time. That's okay. I'll have to go back because, which is not a problem. I love it there. But I was going to go because this is one of my favorites. Whenever they cite the Hague Convention, you know it's good. The Hague Convention, of course, doesn't apply. It involves international law and human rights violations and all this business. They aren't getting into your custody dispute. Which, by the way, you're wrong on every front. You've got a sweet ex-wife who's trying to be nice to you. You're doing meth, which is how you cooked up this Hague Convention idea. And here we are.
All right. Bear with me 1 second. So the Hague application is time and place and circumstances of wrong removal or retention. 3 p.m. Wednesday, August 14th, mother dropped off father at Center Stage Dance Studio Plaza for father to complete moving furniture. Upon completion, was led to believe that the mother all would be joining plaintiff mother and grandmother for dinner that evening. Mother explained a 24-hour break period from the conflicts of raising a young boy. Time spent at defendant's Paris address at 231 Deer Path. Factual and legal justification for request. Since birth on 11/1/20, habitual and sole residence has been my address at 4069 Rio Grande.
All right, I'm coming over.
This is 5 continued. So time which, okay. He spent time at parents' house for a 24-hour period. Opportunity for her parents to watch the minor child while the mother continues to elongate separation period from father and has since cut all communication with the plaintiff father.
I am actually impressed with both the ex-wife and her attorney. They are both holding back so well. He deserves laughter and derision, but they're not doing it. They're pros.
Based on the above testimony declaration, I'd ask that the court to see that it necessary to honor the application of the Hague Convention to rule for the minor child to be returned to his only known address. Plaintiff would maintain an open communication policy with the defendant and pray, God willing, we can, as adults, continue to raise a very special boy without further needing the time of the court. Proposed arrangements for return. His mother would open the line of direct communication and make arrangements for her first day off following notice. Other persons and additional information. Jim Alderink, the grandfather, same address, 231 Deer Path. Kathy Alderink, grandmother, same address. Mary, the mother, same address. Other relevant information. Mother has removed minor child from established residence. Mother has also severed all line of communication except that through specifically the grandfather, Jim Alderink, via text mostly. Plaintiff father would like to remain open-minded to the mutual arrangement between parties involved, understanding the importance of responsibility and not limiting the time of the court.
Okay, anything else, sir?
That is the end of that application.
Okay. Well, in this particular matter, the court notes that based upon the pleadings and the argument that the parties did separate on or about August 14, 2024, that the child has been in the care of the plaintiff since that time, and the defendant has not had any parenting time since then for various reasons as stated by the plaintiff. The court is going to therefore continue the status quo and grant to the plaintiff the custody of the minor child. The court will, in this matter, set support pursuant to the child support formula.
This adds to my usual theory that you can decide 95% of these cases on demeanor. When people act like the way Mary's acting and Kelly's acting, they're 95% of the time right. Not always, but when you're that calm, you know you got the goods.
Ms. Podolsky, what I'm going to do at this point is I don't know. I'm going to impute income to him as based upon what his income was with the Liberty Commons apartment when he was last working at that place. The court would grant to the defendant supervised parenting time, supervised by the paternal grandmother on basically alternating weekends from starting on November 8, 2024 at 6 o'clock p.m. to Sunday at 6 o'clock p.m. that he would have his midweeks on starting on November 6, 2024 from 4 to 8 o'clock p.m. and alternating holidays based on the front of the court holiday schedule, and that those would be supervised as stated. If in fact the defendant were to appear to exercise his parenting time, and if he is under the influence in this particular matter, that the parenting time would end at that time whenever he were to show up, if he is in fact under the influence. Ms. Podolsky, you can prepare that order and submit under 7 days.
Okay, thank you.
Thank you. You're free to go. Have a good day.
Thank you. You as well.
Your Honor?
Yes.
Could you refer me to the next, my appeal for this judgment?
Your what?
Appeal to this judgment?
You can appeal anything you want, sir.
Right. So would that go to Hallacy?
Nope, it would go to the Michigan Court of Appeals.
Always good when you're thumping your chest about appealing a judge's order, and then you have to beg him where to appeal to because you don't know anything about anything. Oh, good Lord.
Okay, thank you.
Okay, thank you.
Well, there you have it. The easiest call of the day for the judge. Motion granted. The right thing happened. The right party won. It was so calm, it doesn't even look like it. Nobody's doing a victory lap because it was so obvious. Well done on everyone's part, except for Cookie Man, who thinks he's taking his custody fight to the Hague. Although he did provide us some entertainment. I really am. I'm going to the Hague. I was there and I hadn't been to Amsterdam before, and I had like 2 days. It's not that far. Like you can take an Uber from Amsterdam to The Hague. I don't know. It's probably an hour and a half or something. I was gonna do it and just stand outside wherever the Hague Convention cases are held and take a damn picture, because it just tickles me every time we get a reference to The Hague, which is never relevant to the people who are making it. and it's all sort of like a powerless joke anyway. Like it doesn't have any enforcement mechanism. It doesn't have jurisdiction over this. It's not applicable. Whatever. But this guy thinks he's gonna knock the judge off his chair with a suggestion. Good times. Good times. Thanks for coming out. I appreciate it. I will see you soon.